there's no history of that kind of restriction.
Right.
Right? We're the Arms Attorneys. Today we're talking about an incredibly important case that was just decided out of federal court in Texas, Firearms Policy Coalition versus McCraw. This is the first case that we know of that's been decided with the Bruen standard. And we now know that 18 to 20-year-olds must have the right to carry handguns in public. Stick around for all of the breakdown of this case. And before we get started, show your support for the Second Amendment by hitting the like button.
And to give a little context to this, we're talking about Texas's constitutional or permitless carry. That was passed in the 87th regular session, HB 1927. And essentially what it said is it removed the general licensing requirement to carry in public. Now, when it passed and went into effect September 1st, 2021, it still remained or left behind a general prohibition on 18, 19, and 20-year-olds carrying unlicensed in public, and we're talking about handguns, so they could really only carry inside of their house, premises under their control, and concealed in their vehicles. Now, what's interesting about this, when this law passed and it was debated on the House floor, there was an amendment offered by Representative Kaysen to lower that age. We wanted to lower it down to 18, and that amendment did not pass. I want to say only 12 people voted for it, and 120-something people said no. So when this thing finally, made it out of the House of Representatives, when we were talking about Texas permitless carry, we're talking about 21-year-olds and older. And so that's kind of the law that we've had into effect. And then we have this incredible lawsuit from the Firearms Policy Coalition. They found a plaintiff here in the state of Texas who was under the age of 21, wanted to carry a handgun for self-defense in public. And what's going on with that case?
Well, what we have is, two young men who did not get into trouble for anything. They filed this lawsuit along with the Firearms Policy Coalition saying, basically, I am harmed by this. I'm not allowed to carry my handgun. And if I do, I risk prosecution. And that's enough to give you standing. So they have good standing for the case. And we had what cross-filed motions for summary judgment. Basically, the state of Texas filing to say, you don't have standing, right? No harm has occurred. You have to get arrested first, basically.
Right.
And go from there. And then we had the Firearms Policy Coalition filing on motion for summary judgment based on New York State Pistol and Rifle versus Bruen, and this brand new standard that we must impose, not our two-step old standard, this brand new history and tradition standard for Second Amendment violations. And the judge granted Firearm Policy Coalition's motion for summary judgment, said that we must allow, based on New York State Pistol and Rifle versus Bruen, we must allow 18 to 20-year-olds to carry in public because there's no history of that kind of restriction.
Right.
Right?
Yeah, and the court went on to rule that this general prohibition on 18, 19, and 20-year-olds, as so far as it's contained in the Texas's permitless carry scheme, that the state of Texas is enjoined, that officers, that agents for the state, they can no longer enforce the law as written, and that we would need to allow 18, 19, and 20-year-olds to be allowed to carry handguns generally in public for purposes of self-defense. Now, what is, this doesn't go into effect immediately. That's a question we'd be getting a lot. When would this law theoretically go into effect?
Well, the judge did something sort of unusual. He stayed his own order because this is big, right? I mean, this is big. Normally, you just issue an injunction, you're enjoined. But this changes a lot for a lot of people in the state of Texas. So he stayed his own order for 30 days. Or let's say that the state of Texas appeals, and then as part of the appeal process, there's, the appellate court's going to issue a stay until the appellate process plays out, basically. So either or, 30 days, or based on what happens in the appeals process until the appellate process has played out. Now, if that's the case, my gut says, given the fact that we start our legislative session here in January,
right,
that we probably legislate this before it makes its way through the Fifth Circuit. I don't know.
Yeah, that's the destination of this case. If it, ultimately gets appealed by the state of Texas, it would go to the Fifth Circuit Court of Appeals. But we reached out to Representative Matthew Schaefer. He was the primary author who led the charge on Texas permitless or constitutional carry going into effect. We asked him, his reaction to the news from this court, and he said, "Do 18-year-olds have full constitutional rights or not?" I say yes, and the Second Amendment is clear. A country that can compel you to defend your country in war must allow you to defend yourself at home. So that's from Representative Matt Schaefer's take on, what the court has, essentially said in this case, which is very interesting. But that's not the end of the road yet, because the court did give the state of Texas a few outs. And so what's kind of the rest of the story here?
Yeah, well, so let's talk about how Texas can fix this, because the court didn't just say 18, 20-year-olds could do whatever they want. He sort of laid out in his opinion, this is how you fix the problem. And I'll just sort of tick them off, and then you can expand on them if you care to. So we could just allow full constitutional carry for 18, 20-year-olds. Great.
Easy.
Fixes the problem. Easy. If we didn't want to do that, but we would allow them to get licenses, handgun licenses, that would also fix the problem. Because the problem here isn't they aren't allowed to constitutional carry. It's they have no avenue to be able to carry. Mm-hmm. So we could potentially say, look, 18 to 20-year-olds, you can't carry unless you're licensed. That would be fine.
Or they could pick a lane, prohibit carry for, maybe they say 18, 19, 20-year-olds, you can't open carry, but you still must be allowed to conceal carry. Or vice versa. You can't conceal carry, you have to open carry. We see that in a lot of states. You remember about the history of concealed carry laws and why we have them. We see that only criminals used to conceal carry because honest, trustworthy people who had nothing to hide carried their firearms and handguns in this case openly. So maybe picking a lane there. And what was the fourth, kind of issue the court raised? Yeah,
this was interesting because he actually, Judge Pittman actually laid it out in footnote number 9 of his opinion, where, he sort of says, or, who knows, you could put some other restrictions in there for 18 to 20-year-olds, some other hoops for them to jump through, so long as it's not a substantial burden on their right to carry. You could, potentially, Lord knows, maybe it's like constitutional carry with our little criminal history,
carve out.
But we say, well, 18, 20-year-olds have to be this or do this in order to engage in constitutional carry. There's basically, I think, with that footnote, he left open many, many, many options. My takeaway is, as long as there is some avenue that doesn't substantially burden the 18 to 20-year-old, they get some avenue to carry the handgun in public. That's all we need. But that is huge.
Yes. Huge. Yeah. And I would say the one other thing to that footnote would be, I still think it would be analyzed under the scrutiny of New York State Rifle and Pistol Association v. Bruen. So that goes back to the, how great is the, does the conduct, or is it covered by the Second Amendment? Does this infringe on it? And is there a history and tradition for it? Well, and what we saw at a New York State Rifle and Pistol Association, there are areas that the government historically did regulate. And so maybe pops up in one of those types of forms, maybe where they couldn't or could not carry, or maybe they require a peace bond, or, things that we've seen that are rooted in the text and history and tradition of the Second Amendment.
I think the big takeaway here, though, is that this is important. It's not just important to Texas between the ages of 18 and 20. This is the first.
Yep.
This is what is to come on Second Amendment cases. Pull the opinion, read it. You're gun people. You like this stuff. You're going to like it. It really lays out. I think you can insert anti-2A law in your mind into this opinion, see how it stacks up, and know that we are about to get a lot freer in this country.
Yeah, this is I would say the canary in the coal mine, and it's looking good for us at this point. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting the like button, and help us fight the anti-2A algorithm by sharing this video.
And please continue to question and comment below. Tell us what anti-gun law you'd like to see come down next. Until next time, we're the Armed Attorneys.